Hello everyone, my video today is all about sole traders. And the reason for this video is to help agencies better understand these types of contractors, particularly as we're seeing a resurgence of sole traders in light of the dreaded off-payroll rules coming into force in April this year. So my job today is to try to demystify this often misunderstood payroll model and explain how agencies can compliantly supply these types of individuals to clients. The Office of National Statistics, ONS, suggests there are over 5 million self-employed people in the UK, and the majority, possibly 70% or more, are sole traders. So this is clearly a popular route to market for individuals looking to become self-employed. But many agencies don't understand what sole traders actually are. So that's where I'm going to start. Sole traders are individuals who trade as a business in their own name. So sole traders act as an individual. They don't work through any sort of intermediary, such as a limited company or a partnership. And that brings me onto one of the main advantages of being a sole trader, how easy it is to become one. Because there's no significant administration or costs involved in setting up in this way. An individual, let's call him Fred Smith, decides to work as a sole trader. He simply needs to choose a trading name, though most sole traders use their actual name, and register for self-assessment with HMRC, which is relatively quick and usually can be done online. If Fred's business is doing really well and his turnover in a year is more than the £85,000 limit, then he'll also register for VAT. But his VAT certificate will be in his own name or his trading name if he's chosen one, as opposed to a company name. So Fred Smith decides to use his given name as his trading name, that is Fred Smith, and he registers for self-assessment. He'll be given a unique tax reference number, or UTR, by HMRC, and off he goes. He's ready to start trading. He doesn't even need to set up a separate bank account to manage all his invoices and payments as part of the sole trader business, but most of them do. Unlike contractors who work through their own limited company, a sole trader is personally liable for his or her business debts, and his or her personal assets may be at risk if creditors can't be paid. So that is an important difference and potentially a significant disadvantage of working as a sole trader. Limited company contractors always have the option to dissolve their limited company and walk away from debts or liabilities, but that isn't an option for sole traders. Let's look at what happens when sole traders work directly for clients without going via an agency. Fred Smith carries out paid work and invoices his clients in the name of Fred Smith. He may charge on fixed price or time and materials basis. He keeps records of all of the work that he does, that he charges for, and all the expenses he incurs to run his business. Fred tracks his turnover on a quarterly basis to calculate and pay his VAT liabilities if he's registered for VAT, and at the end of each tax year he completes a self-assessment in order to tell HMRC all about his income and his outgoings of the previous year. Either using the online self-assessment tool or some other calculator, Fred works out the income tax and national insurance contributions, or NICs, that he must pay to HMRC on his profits. Now, it should be noted that sole traders will pay Class 2 and Class 4 NICs as opposed to Class 1 NICs that employees pay. And clients engaging with sole traders aren't required to contribute any employer's NICs either. A problem with sole traders, from HMRC's perspective at least, is the risk of sole traders not declaring their total income, which of course can reduce their VAT, the income tax and NICs payable by the sole trader each year. I'm sure everyone's experienced a situation where a sole trader has offered to do work for one price and then offered a slightly lower cash price. Well, One reason for that may be that the income from that job won't be declared to HMRC. So how is the process different if an agency engages a sole trader to supply onto end clients? Well, when I'm looking at contractor payroll models, I always ask myself, what does that model mean in terms of a worker's employment rights eligibility, and what does that mean in terms of taxation? So that's how I've split this slide out. Firstly, it's important to realise that because there's no intermediary, such as a limited company or an umbrella company, you as the agency are engaging with the worker directly as an individual, and that removes any sense of an arm's length relationship between you and the sole trader. Because there is no intermediary, sole traders aren't able to opt out of the conduct regulations even if they want to. So the conduct regulations will always apply to sole traders. Secondly, sole traders may be in scope of the Agency Worker Regulations, or AWR. As you'll know, AWR applies to any individual defined as an agency worker, and that definition covers 3 areas. Firstly, the individual needs to be supplied by a temporary work agency to a hirer or a client. That's certainly the case here. Secondly, the individual works under the supervision and direction of the hirer. Well, that's a maybe, depending on the circumstances of the particular assignment. And thirdly, the individual has a contract with the agency to perform work and services personally. And that is the case in this scenario as well. So 2 out of the 3 requirements in order to be protected by AWR are already fulfilled. So it all comes down to the question of supervision and direction, and we'll come back to that point in a few slides' time. In relation to other employment rights, including things like sick pay, holiday pay, maternity pay, pension enrolment, sole traders are generally considered to be self-employed, meaning they're not eligible for these types of employment rights. However, there's nothing to stop a sole trader from claiming that they are entitled to some rights, either as a worker, which is a kind of hybrid status in employment law that offers some employment rights and protections, or as an employee, which, as we all know, provides the most employment rights. So there are what we call implied employment risks when dealing with sole traders. If there is a dispute about entitlement to rights, an employment tribunal will use established case law to determine status and therefore rights eligibility. These case law tests are things like personal service, control, mutuality of obligation, integration, financial risk, and you'll no doubt have heard of these terms before in relation to the off-payroll rules or IR35 regime, because of course courts use the same factors or indicators when determining tax status as they do when they determine employment status for rights purposes, albeit the factors are applied and weighted slightly differently. My advice, therefore, would be to make sure you have good contracts in place, clarifying the status of the sole trader, and that the relationship with you as an agency and with the client is clear, and make sure that you and the client are treating sole traders as genuinely self-employed individuals. Now let's look at the tax position. Many agencies and end clients believe that sole traders are captured by the off-payroll rules that are currently in force for the public sector and due to be extended to the private sector from the 6th of April this year. But that's just not the case. The off-payroll rules require the worker performing the services to operate via an intermediary in which they hold a material interest. But sole traders don't use an intermediary, such as a limited company. The worker contracts directly with the agency as an individual. So that means, by definition, the off-payroll rules can't apply. Instead, agencies need to look to the 2014 Onshore Intermediaries legislation, or agency legislation, as it's often called by HMRC. And I'm going to explain how the legislation applies in the next few slides. Also, many sole traders work within the construction industry. So many sit within the Construction Industry Scheme, or CIS. And I'll cover the interaction between the onshore intermediaries legislation and CIS briefly a bit later on. But if you want to know more detail, please do feel free to contact me directly. Finally, if you're involved in the construction industry, you also need to consider the VAT reverse charge taking effect from the 1st of March this year. Now, these new rules don't apply to recruitment agencies supplying temporary staff, but it will affect your clients and possibly some of your contractors as well. So it's worth making sure that you understand the implications of this new tax law as well. Before the onshore intermediaries legislation was introduced, many agencies regularly used sole traders, particularly in construction and transport, but in many other sectors as well. As we've seen, it is an easy model to set up and manage, so it's popular with contractors. And for agencies, well, there were minimal compliance requirements. Agencies simply took a copy of the contractor's unique tax reference number, or UTR, alongside other documents such as their right to work, etc. And that was it. The agency would then simply pay the contractor gross into their personal bank account, and it was the contractor's job to manage his or her own tax and NICs. However, unions in particular felt that this payroll model was being abused by recruitment agencies who were forcing individuals into becoming sole traders in order to avoid providing them with full worker rights. And the government picked up on the concerns of the unions, but instead of legislating to ensure these types of contractors were given clarity on their employment status for rights purposes, instead they simply focused on the tax position instead. So the onshore intermediaries legislation was introduced in 2014 to combat what the government called false self-employment, but it relates to tax status only, not eligibility for employment rights. The actual wording is set out in Chapter 7 of Part 2 of ITIPA, which is the Income Tax, Earning and Pensions Act 2003. What the legislation says is, if any agency engages with an individual, a worker, to personally perform services for a client, and the manner in which those services are provided is subject to supervision, direction or control by either the client or the agency, then the agency must treat the worker as an employee for tax purposes. That means income tax and employees' NICs must be deducted from the assignment income before payment is made by the agency to the sole trader, and the agency supplying the sole trader must also contribute the employer's NICs to HMRC as the employer for tax purposes. Because the deductions and payments for tax and NICs needs to be done via real-time information, so in other words via payroll, then that individual also contributes to your pay bill numbers for the purposes of the apprenticeship levy. So 4 extra elements for agencies to think about. Now let's break that legislation down a bit. So the agency must be supplying an individual, and the individual must be personally performing services for a client. Well, that will always be the case with sole traders, since it's Fred Smith, the individual, that the agency engages with. So there will always be a requirement for personal service in this scenario. So the key question really is the supervision, direction and control aspect. Now let's look at this element in more detail. And we usually refer to this aspect of the legislation as the SDC test. Now the first 3 bullet points on the slide are HMRC's definitions or examples of each of these factors. And I won't read them out word for word because you can read them for yourself. But when you do, you'll see that the definitions and examples are very wide, by which I mean they will apply in many circumstances. Now, for those of you who know about IR35 or the off-payroll rules in any detail, The terminology supervision, direction and control may sound familiar, but this is not an IR35 test. It isn't the same as the control element of IR35. It's important to make that distinction between control under IR35 and SDC for sole traders, because they are not the same test. Similar, yes, but not the same. The next point to note is that it's not just actual supervision, direction or control that affects whether the sole trader is employed or self-employed for tax purposes. The legislation makes it clear that even a right to exert SDC by either the client or the agency is sufficient for the legislation to apply. And in effect, that's making those definitions wider still. Thirdly, the burden of proof is against you. And by that I mean the legislation is worded in such a way to state that you are required to deduct tax and NICs unless and until you can prove that an individual is not subject to or subject to the right of SDC. Now, just a final point to note here, the onshore intermediaries legislation is aimed at agencies only, and it's only agencies that are responsible for complying with these rules. End clients aren't subject to this piece of legislation, so hold no liabilities in this area. There is therefore a potential opportunity for agencies to introduce sole traders to end clients, for them to engage the sole trader directly and simply pay the agency a one-off fee, similar to a permanent placement fee, but reduced pro rata for the expected length of the assignment, or engage with the end client on a margin-only basis. Now, you may think that clients will simply dismiss this option out of hand, but actually, I know of quite a few client companies who want to engage with sole traders, but agencies don't really want to supply them because they're not sufficiently confident that they can compliantly manage their legal obligations. These clients are taking a more pragmatic approach to the issue and agreeing to engage with sole traders directly. The onshore intermediaries legislation also doesn't apply to the sole trader him or herself, but HMRC could still pursue the individual under other legislation relating to disguised remuneration. In fact, there have been a few recent cases in the First Tier Tax Tribunal that indicate that HMRC have on occasion chosen to pursue individual taxpayers having exercised their discretion to absolve the supplying agency of their liabilities to make PAYE deductions. Speaking of liabilities, I just want to briefly cover the penalties relating to the onshore intermediaries legislation. Where an agency fails to comply with its obligations, it would be liable for the tax gap, if you like, as well as interest if the non-compliance related to previous tax years, and potentially additional penalties for non-compliance. Now, the tax gap is the income tax, employees' NICs, employers' NICs, and, if applicable, the apprenticeship levy amounts that should have been paid to HMRC and weren't. Interestingly, where there are multiple agencies in the chain, the legislation makes the agency closest to the client primarily liable for any non-compliance, which is why all MSP and RPO contracts prohibit their second-tier agencies from using sole traders. And similarly, if you are an MSP, you won't want any of your second-tier agencies using sole traders either. So this payroll mechanism is realistically an option only where you contract directly with the sole trader and with the client, meaning you're the only agency in the supply chain. When might you be liable for non-compliance? Well, the most obvious scenario is that you believe the sole trader is not subject to SDC and pay him or her gross, that is, without any deductions, and at some point in the future HMRC disagrees or believes your evidence to be insufficient. You could also be liable if you do deduct tax and NICs, but for some reason you don't deduct the correct amounts. Now, that's relatively unlikely, seeing as using RTI minimises the risk of errors, but I am including it as a scenario just for completeness. How do you go about conducting an SDC test? Well, firstly, it's important to note that it's a 3-limb test. So that means supervision, direction, and control all need to be considered in their own right, as well as collectively. So when deciding whether SDC applies, make sure you question each element. It's also important to realise that the legislation states supervision, direction, or control, meaning that if just one of the elements is present, then the legislation applies and tax and NICs must be deducted. Your contracts with clients and sole traders need to clearly evidence that SDC isn't present. But contracts alone won't be enough. You'll need to have solid evidence that the day-to-day working practices of each assignment align with the contractual position. Just writing an SDC-friendly contract won't cut the mustard exactly in the same way as an IR35-friendly contract won't for IR35 purposes. So you'll therefore want some kind of questionnaire or documentation that both the client and the sole trader contribute to, that covers at the very least the areas listed here on the slide. Now, there's no doubt that some roles, and indeed some entire sectors, if they're highly regulated, simply aren't suitable or conducive to the use of sole traders. It's not a one-size-fits-all model, that's for sure. But it's also not impossible to work compliantly with sole traders in a variety of sectors and industries. And particularly in light of the off-payroll rules, I think we'll see more agencies using this model in future. I know it sounds like a lot of hassle and a potentially impossible task, but you also need to appreciate that HMRC needs to enforce the legislation. And this is one of the reasons why I say that the client needs to be involved in the SDC questionnaire or process. Because if HMRC come knocking on your door at some point in the future for any reason and ask to look at how your contractors are engaged and asks how you've determined that certain sole traders are not subject to SDC, the more aligned that you, your client, and your sole trader are, the more difficult HMRC's job becomes if they believe SDC may have been present. Yes, the burden of proof is on you to prove that SDC isn't present, but HMRC do need to give evidence as to how or why they believed you failed to apply the law correctly. And the only way to do that is to talk to the sole trader and the client and try to undermine the contents of the questionnaire or documentation that you're holding on file. If everyone is aligned from the start and sole traders are only used when they're truly suitable, then HMRC really has nowhere to go from there. I know of at least 5 agencies who've had their sole trader processes investigated by HMRC. And each time, because they've got solid documentation and everyone's been involved in completing the SDC test, HMRC have confirmed that everything is in order and simply left them alone. Some agencies aren't comfortable or confident in putting together their own SDC process and questionnaire. And if that's the case, then they have a couple of options. As I've already mentioned, the agency could agree with the client that the client will engage the sole trader directly and simply pay the agency on a margin-only basis. But the other option is that the agency decides to engage with some sort of payroll intermediary to help them. Payroll companies are very familiar with the SDC test because the same test applies for umbrella company workers who want to claim tax relief on their travel and subsistence expenses. Now, it's a totally different piece of legislation affecting a completely different type of worker, but the same SDC test is used for some reason. Many payroll companies also offer a CIS payment option. And of course, most construction workers are sole traders. So this means payroll companies are generally very comfortable with SDC and have robust questionnaire templates already in use. It's a perfectly legitimate approach to engage with a payroll company to support you. However, you do need to appreciate that inserting a payroll company into the chain doesn't absolve you of liability, because if you remember, it's the employment intermediary closest to the client who holds primary liability under the onshore intermediaries legislation. So even if you put another company into the supply chain between you and the sole trader, you're still liable for any non-compliance with the onshore intermediaries. So you can outsource the process, but not the legal risk or liability. Certainly, you would want to conduct thorough due diligence on the payroll company to make sure it's conducting a robust SDC test, and most importantly, ensuring that any contractors who fail, for want of a better word, the SDC test are being paid on a PAYE basis. The checks that I would do as a minimum are ensuring that the provider is FCSA accredited and maintains their accreditation for as long as you're working with them. The FCSA is the Freelancer and Contractor Services Association. It's a trade body for the payroll industry and has the highest compliance standards in the industry. You'll also want to ensure that the provider is financially stable. Don't forget that non-compliant payroll companies can and will simply dissolve overnight, but that risk is somewhat reduced, though by no means eliminated completely, if it is a financially viable business. Make sure you obtain and keep on file evidence of how their processes work and evidence of their compliance, and conduct spot checks every few months by requesting payslips or similar to ensure they really are doing what they say they're doing. Now, while it's tempting to forget about the due diligence and rely simply on contractual indemnities to protect you, remember that if the payroll intermediary ceases to exist for any reason, then the indemnity will be worthless. Finally, the last point on this slide, if you do decide to work with a payroll company, you'll need to agree what their costs to provide the service will be and who is paying for it. Will it be you, the agency, or will the sole trader have to pay the service fees? Onto the process for payments now, and these slides assume that you'll be engaging the sole trader directly as opposed to using a payroll company. If the sole trader passes the SDC test, that is, you've determined that the worker is not subject to or subject to the right of SDC, he or she can be paid gross, by which I mean no deductions are made for income tax or NICs. Where you pay the sole trader gross, you're not then required to contribute any employer's NICs, and of course the contractor won't be on your payroll for the purposes of the apprenticeship levy either. So that means you have no additional costs to consider other than your margin and the sole trader's pay rate. Make sure you keep copies of all the SDC tests you undertake for each assignment in case of an audit in the future. And remember, HMRC can investigate you for any type of tax non-compliance up to 6 years later. So you'll need to keep all of your evidence for at least that period. Any payments you make to contractors that are not via payroll have to be reported to HMRC using the ITPA quarterly reporting process, which I'm sure you're all familiar with already. HMRC does use these reports to find agencies who supply sole traders and conduct compliance checks into their processes. The contractor then manages his or her own income tax and NICs payments via self-assessment on an annual basis. If the contractor fails SDC, then he or she is considered an employee for tax purposes. And you as the agency are considered his or her employer for tax purposes. So that means income tax and employees' NICs must be deducted at source, so before you make payment to the sole trader, and you become responsible for paying the employer's NICs and the apprenticeship levy if it applies to HMRC. Since the deductions and payments to HMRC need to be done via real-time information or RTI, you don't need to report these payments in your quarterly ITPA reports. If you cast your mind back, one of the first slides I talked through, I mentioned employment rights and how they apply to sole traders. If a sole trader is subject to SDC, then the contractor sits on your payroll for the purposes of payments, but he isn't or she isn't automatically considered to be a PAYE agency worker. He or she is still considered a sole trader and therefore technically not entitled to employment rights. But particularly in relation to AWR, which applies if the individual works under the supervision and direction of the hirer, there's a very strong argument that any sole traders who fail an SDC test for tax purposes are of course subject to supervision and direction and would therefore be protected under AWR. There's also an argument that these individuals could be entitled to other worker rights as well, if you consider the established case law in relation to this scenario. And often that puts agencies in an uncomfortable position. So generally, sole traders who are assessed to be subject to SDC are then required by the agency to move to an agency PAYE model or a PAYE compliant umbrella, in which case, of course, their status for both rights and tax purposes are completely clear and unambiguous. Finally, I want to briefly cover how the construction industry scheme interacts with the onshore intermediaries legislation because, as I've mentioned, many CIS subcontractors are sole traders. CIS is also a tax collection scheme, but it applies only to construction activities, though that definition is very wide. It requires a withholding tax to be applied to any payments for any construction-related work. It is secondary to the onshore intermediaries legislation. So, when you're supplying sole traders for construction-related projects, you conduct the SDC test first. If the sole trader fails the SDC test, meaning he or she is subject to SDC or the right of SDC, then of course you are required by law to deduct and pay income tax and NICs, as we've already spoken about. Where that's been done, there's no need for you to apply the CIS withholding in relation to those payments. If the SDC test is passed, then you as the agency will need to verify the sole trader's subcontractor status for CIS purposes and apply the relevant withholding amount, usually 20 or 30%. Payments to the sole trader are then reported in both the quarterly ITPA reports or RTI and your monthly CIS returns. That's it from me for now. Thank you very much for watching this video and I really hope you found it helpful. If you have any feedback about this session or you want to check out my other videos and content, then please do visit www.labvolution.com. See you next time.